Welcome to part 2 of my 5-part series, Family Law Introduction to the Basics. My name is Gail Lee and I am a solicitor at McHugh Lawyers in Chatswood, Sydney. In part 2, we will briefly cover the topics of separation and divorce. Okay, now before we begin, it is important that you understand that the end of a relationship is a process. There are stages of separation and it's not uncommon to find that parties to a separation are at different points in their processing. This is especially so when one party did not see it coming. One of the most important things to understand is that the decisions you make now and how each of you behave from the beginning will directly impact the degree of difficulty you have moving forward. Look, ideally parties will plan the least costly way to manage their separation, but that involves maturity, respect, honesty, and even contrition. Part 2 of my series on family law basics deals with an application for divorce. If you are newly separated, however, you will not be at this stage yet. For you, the most important decisions may relate to practical arrangements, for example, who will move out or whether you stay living under the same roof but no longer as a couple, how to finance the move, also parenting arrangements if there are children involved, and also the preliminary discussion of property settlement. The reality is you are no longer together, but you are both going to need to make joint decisions to effect separating, ideally with as minimal amount of damage as possible to each other and your kids. Alright, so to be granted a divorce in Australia, you need to meet some of the basic requirements. The first of these is jurisdiction. You will be eligible to apply for a divorce under Australian law if you or your spouse, so notice that, or is an Australian citizen by birth, descent or grant, or either of you or your spouse ordinarily lives in Australia, or has lived in Australia for at least a year before applying for the divorce, or regards Australia as home and intends to live here indefinitely. The court must also be satisfied that a valid marriage actually exists. Now previously this was a problem for same-sex couples in Australia who married overseas because our legal system did not recognise their marriage. This, however, is no longer the case. Now, if there are issues concerning the validity of a marriage, you really need to seek legal advice first. We have a no-fault system for divorce, so it's not necessary to prove that someone has done anything wrong to justify granting the divorce. The only thing the court needs to be satisfied with is that there is an irretrievable breakdown of marriage. The way this is proven is by demonstrating that you have been separated from your spouse for 12 months. So tip, note the date of separation down somewhere because you will need it for your application. Now, the date of separation must be at least 12 months prior to the application for divorce. There are 3 essential elements to separation. These are intention, action, and communication. Ideally, you'd have documentary evidence, but as solicitors, we appreciate that's not always the case. But look, documentary evidence of the date of separation is helpful where there is a difference of opinion as to when separation took place. Now, you might be thinking, why should it matter when we actually separated? We've separated. It matters because you will need to note it in your divorce application, as I mentioned before. And also, if a dispute arises with respect to other issues, such as ownership of property and financial obligation, it may become very important then as well. So remember also, if you are relying on the jurisdictional requirement that at least one of you has been living in Australia for 1 year before your application, you again are going to need to know the date, or at least a close estimate to it. Now, in some instances, parties may resume their relationship in the hope that they are able to save their marriage. If this is relevant to you, Section 50 of the Family Law Act permits one period of up to 3 months cohabitation without the need to restart the 12-month separation period again. So let's say, for example, on the 1st of February, you tell your partner that you want a divorce. On the 1st of March, you both decide to try and give it one more go. So you have already got 1 month on the clock for your 12-month separation. You then, however, split up again within 3 months from the time you reconciled. The 1 month you already have on the clock, that being the period from when you first broke up and when you got back together, will still count. Now, if you have both continued to live together under the same roof, even though separated, so this is another issue, you will need to you need to provide details of this in your application. Now, generally speaking, when couples separate, there is no requirement that one party must move out of the marital home. So obviously though, if there are issues concerning safety or staying under the same roof would leave children exposed to conflict, then leaving may be the best option. If you are unsure as to what you can or should do, then go and seek advice. Don't feel, however, that the decision as to who stays and who goes depends on whose name is on the title or the lease, because that's not the case at all. It is a question of financial capacity, what is fair, what provides the greatest stability for the kids, personal safety, and the needs of the parties. All right, so let's take a moment and look at what happens if you have a marriage that's less than 2 years in duration. Now, generally speaking, the court cannot hear an application for divorce where the parties have been married less than 2 years unless the parties have been to a family counsellor who has assessed the prospects of reconciliation, or the court is willing to dispense with the requirement for counselling because special circumstances exist. Now, these special circumstances include where there is evidence of family violence, or perhaps the respondent's whereabouts is unknown, or the parties live somewhere that make attending counselling impossible, or there has been significant litigation between the parties in relation to matters concerning children or property during the 12-month post-separation period. Now, if you are unsure whether you would be able to satisfy the court that special circumstances exist, you should seek legal advice. Note also that the 2-year period begins from the date of marriage and ends on the date of signing the application for divorce. So if you were married for less than 2 years, however, you have not signed the application for divorce for another 2 years, you will not be required to attend counselling. If you are required to attend counselling, make sure that it is with an approved marriage counsellor, otherwise you're just wasting your time and money, as they will be able to provide you with a signed certificate when the counselling finishes. You will need to file this certificate with your application. The court will also need to be satisfied that proper arrangements have been made for any children of the relationship. Now, this is whether they are children born from the relationship itself or children of a previous relationship that were considered and treated as part of the family. If the court is not satisfied that proper arrangements have been made or that special circumstances do not exist to enable the declaration to be made that it needs to make, the court will usually order that the application be adjourned, which simply means put on hold, and that affidavit evidence is obtained to provide the information the court requires. Now, sometimes the court will allow the applicants to give information through their legal reps, or it may be willing to allow the applicant themselves to give oral evidence, but that's not always the case. The type of information you provide to the court regarding the arrangements for the kids includes information about their living arrangements, such as which parent they live with and the time they spend with the other parent, the particulars of any parenting orders that might be in place, and details as to the support provided to the children by the non-resident parent. If there are parenting proceedings on foot, this may, but not always, be sufficient to satisfy the court to make a declaration. Now, in some instances, the court may adjourn divorce proceedings to allow time for a family report to be obtained. Remember, though, an application for divorce is not an occasion where the court will consider or deal with an application for orders in respect of any children. The information it requires about proper arrangements is only relevant insofar that it satisfies the making of a declaration pursuant to Section 55A of the Family Law Act. Now, I know I accidentally just jumped ahead before with point number 8 down there, but we'll move on now to service. So with service, if your divorce application is a joint application, you don't need to worry about service because clearly the other side already knows. If your application is a sole application, however, so you've filed your divorce papers, you will need to provide a sealed copy of the application to your spouse. It must be served by special service, say that again, special service, which means that it must be personally served by the person to be served. So an important point here to keep in mind is that you yourself, if you are the applicant, cannot serve the respondent. Now, a document is taken to be personally served where it is served by hand, by post, or electronically, or if the respondent has a lawyer who is instructed to accept service. So don't assume that the lawyer has instructions to accept service. You need to find that out, and it has to be in writing. Then this would be acceptable. If posted or served electronically, you will have to provide the court with the other side's signed copy of what's called an acknowledgement of service divorce form. You will then need to prepare an affidavit of service by post, if served by post, or if you had it served by a process server, which is far preferable, they will provide you with the signed acknowledgement of service and affidavit of service by hand. Your solicitor may also require you to sign an affidavit proving signature. Tip: if the receiver refuses to take the document, service is still deemed to occur if the person serving the document tells the person being served what the document is and then places it down in their presence. Remember though, if you are serving the documents on your ex's lawyer, as I said before, they must agree to accept service in writing first. If it is not possible to serve the documents by special service, you can obtain orders for substituted service, or in some cases, orders to dispense with service. Now, substituted service is typically used when you haven't been able to locate your ex. In such cases, the court may grant an order allowing you to serve the documents by some other means, so it might be through Facebook or by a friend or family member of your former spouse who is believed to be in contact with your ex. The court may also allow substituted service by prepaid post or email where attempts have been made to serve the respondent personally, but the respondent is believed to be avoiding service. So if you believe you will have trouble effecting service, I would recommend that you seek legal help. Your solicitor will usually be able to preempt what the court would ordinarily require to grant an order for substituted service and will follow the procedure, or at least advise you what you should try to do at first instance. Now, if those attempts to find the respondent are unsuccessful, then an application to dispense with service rather than for substituted service may be attempted at the time of the hearing, and hopefully therefore avoid the cost and delay of adjournment. Okay, so divorce order, it takes effect 1 month and 1 day after the order is made, so it's not immediate. The effect of a divorce, something to keep in mind, is if you have a will and your ex-spouse is, let's say, the named executor, that part of your will automatically be revoked. In some states, though, the entire will be revoked. Same effect as if you were to draft a will and then get married. Unless it's made in contemplation of, then your will be revoked automatically. The effect of divorce on property and spousal maintenance also needs to be kept in mind, because once you have a divorce order that takes effect, the clock starts ticking. You have 12 months in order to file an application for property and or spousal maintenance. If you don't do that within that 12-month period of time, then you'll have to seek leave of the court, or both sides will need to agree before an application for spousal maintenance or property settlement can be made. Right, it is actually not very difficult to apply for a divorce. In fact, many people now manage the application without a lawyer. If you have access to a computer and the internet, you can actually pre-fill your divorce application online. To do this, you would register on the Commonwealth Courts portal, and you can see the web address there. The website will provide a step-by-step guide on how to apply, and you will upload the necessary documents in support. Documents to be filed with the application for divorce itself includes a copy of the marriage certificate. If you were married overseas and the marriage certificate is not in written English, a translation of the marriage certificate must be filed together with an affidavit by the person who made the translation, verifying the translation, and which also sets out the respective qualifications. So it's not good enough that you translate the document. You really need to have it translated by a professional who does this, and they're what we call NAATI translators, so NAATI. Now, copies of documents to prove jurisdiction are also documents which are often need to be uploaded. For example, a copy of an Australian certificate of one or both the parties may be required. Finally, if the application is a sole application, you will also need to file documents relating to service, which is what we touched on before. And don't forget that if you were living under the same roof in the 12 months prior to applying for a divorce, you will need to file an affidavit from an independent witness corroborating corroborating separation under the one roof, and an affidavit by a party as to separation under the one roof as well. Now, I know this sounds like a lot of information, but trust me, as you're going through the steps, depending on your circumstances, it's going to spit out what it is that the court will require in addition to your actual application itself. If you have lost your marriage certificate, you will also need to file an affidavit that the marriage certificate is lost. Now, the filing fee at present is $910, so you can obtain a significant reduction in fees in cases where there is evidence of financial hardship, or if you are otherwise eligible for a reduced filing fee because you are a holder of a Commonwealth Government pension or seniors card. In the case of a joint application, both parties must be eligible to pay a reduced filing fee in order for a reduction to be granted. So if just one of you is holding, let's say, a Commonwealth pensions card and the other one isn't, and it's a joint application, you won't meet the requirements to be able to be eligible for a reduced filing fee. It's also important just to keep note of that court filing fees usually increase on the 1st of January and the 1st of July each year. So if cost is an issue for you, keep that in mind. In some cases, the respondent to an application for a divorce will either want to oppose the divorce outright or argue that the court does not have the jurisdiction to hear the application. Now, if that is the case, they must file a response document at least 28 days before the hearing if they are in Australia, or 42 days if the service was affected overseas. So if you are the serving party, if you are the applicant, keep this in mind, because if you fail to give the respondent adequate time to file a response, your application may be adjourned to allow sufficient time to allow them to respond. Now, if you are the respondent and you do not wish to contest the divorce itself, but perhaps you have an issue instead with the content of the application, so you think something's wrong with the dates or you feel something needs to be corrected, the way to do this is by filing an affidavit setting out the facts in dispute. The affidavit will be filed and served at least 7 days before the hearing date. You do not use a response to divorce to try to correct the record, so to speak. Now, if you also are the respondent and you have an issue with the divorce application, then you must attend court. If you fail to do this, your response to the divorce will not be what we say read by the registrar, and the divorce order may be granted in your absence. So in addition to the sealed copy of the application, I'll just repeat some of the documents that you will need to file. You will also need to, or serve I should say, you will also need to serve sealed copies of any other documentation needed. For example, if the marriage is less than 2 years, an application for leave to file an application for divorce within 2 years of marriage, or an application to dispense with service or for substituted service, or affidavits to be relied on, as which we touched on before. You will also need to provide to the respondent a copy of the marriage, families and separation brochure, which is available on the website, on the court portal. And if you have engaged a solicitor, they are actually obligated to provide you a copy with this and to the other side. Now, other documents that you will need to provide include a copy of your marriage certificate, as I've already mentioned. The unsigned, you'll also need to give the respondent an unsigned acknowledgement of service and a stamped self-addressed envelope so they can send that back to you. If you are not engaging a process server to serve your ex with the documents, so remember to keep those there. That's why it's far easier if you just get a process server. It's like $75 in most cases, maybe a little bit more depending on where you are, and they would be able to serve the documents for you and provide you with the affidavit of service in addition to. Now, the hearing itself, if it's a joint application, there's no kids, you don't need to attend. If it's a joint application and there are children under the age of 18, again, you do not need to attend. If it's a sole application with no children, again, attendance not required. If it's a sole application and there are children under the age of 18, then attendance is required. And remember also, if you are the respondent and you are disputing something to do with the application itself or the divorce, you don't wish it to be granted, then you will have to respond. Now, a tip here is simply that if no attendance is required, the divorce order will be made in chambers by a registrar. If there are any issues, then requisitions will be sent to you, which is like a list of questions that need to be addressed. If attendance is required, you may not need to go, although unless you want to, provided that you are represented by a solicitor. But look, if I had a respondent who was contesting the divorce, I would say, look, you need to come on the day. So thank you very much for listening to part 2 of my 5-part series on the basics of family law. If you have any questions or suggestions as to topics you would like to hear, please feel free to contact me.